Most companies provide benefits to workers as part of total rewards packages that ideally enhance their satisfaction at work. Let's take a look. A benefit is a tangible, indirect reward provided to an employee or group of employees for organizational membership. Benefits often include retirement plans, paid time off, health insurance, life and disability insurance, and many more. Benefits are not typically based on employee performance. Rather, they are provided to all employees who meet certain eligibility requirements. A challenge for employers is how to balance the increasing costs of benefits against the value to the organization and its employees. Exploring new benefit options that are desirable to employees and adopting a strategic approach to compensation that manages pay and benefits comprehensively can help organizations successfully recruit and retain quality employees. Overall, benefits should be a key consideration in the total rewards package when determining organizational strategies regarding compensation. The benefit approach adopted as part of total rewards depends on many factors, such as the size of the organization, workforce competition, organizational life cycle, employee demographics, financial circumstances, and corporate strategic approach. Benefits can be used to create and maintain a competitive advantage for the organization. While they represent a significant cost, benefits are an important factor in employee commitment and retention. Attracting and retaining employees and increasing productivity are business objectives that can be enhanced through effective design of benefit programs. Benefits can influence employee decisions about which employer to work for, whether to stay with or leave an organization, and when to retire. What benefits are offered, the competitive level of benefits, and how those benefits are viewed by individuals all affect employee attraction and retention efforts. A benefit is a tangible, indirect reward provided to an employee or group of employees for organizational membership. During World War II, wage and price controls were instituted to ensure appropriate use of resources and keep inflation rates low. Wishing to attract and reward hardworking employees, organizations began to offer paid fringe benefits as added incentives. Since benefits were not paid in wages, they never were taxed as income to the employee, yet the organization could deduct the cost as a business expense. This explains why the United States differs from many other countries in how benefits, especially health insurance, are provided to workers. The tax favor status means that every dollar in employee benefits is actually worth more to an employee. For example, if Sally is an employee who's in the 25% tax bracket and earns an extra $400 special bonus, she'll pay about $100 in taxes on that amount. So her special bonus increases Sally's total rewards by only $300. But if Sally's employer provides her with group legal insurance benefits worth $400, she receives the full value of $400 since it's not reduced by taxes. This tax-favored status makes benefits a desirable form of compensation to employees if they understand the value provided by the benefits. Organizations design benefit plans with the goal of providing value for employees while remaining cost-effective for the company. Many key decisions must be made as part of benefits design. As part of both benefits design and administration, employers may offer employees choices in benefits. A flexible benefits plan is a program that allows employees to select the benefits they prefer from options established by the employer. As a result of the changing composition of the workforce, flexible benefit plans have grown in popularity. Flexible benefit systems recognize that individual employee situations differ because of age, family status, and lifestyle. Another problem can be adverse selection by employees, a situation in which only higher-risk employees select and use certain benefits. For example, employees with young children are far more likely to enroll in orthodontia benefit plans that provide braces than are older employees. Since insurance plans are based on a group rate, the premium rates might be higher because too few employees who do not need braces enroll in the plan. Another key design issue is whether to provide benefits to part-time employees. Many employers do not provide part-time employee benefits except some paid time off. Benefits for part-time employees are often provided in proportion to the percentage of the full-time work they provide. Still, another concern relates to whether employees are designated as part-time workers, which can affect their eligibility for benefits in a company. Besides what's specified in certain laws and regulations, organizations can create their own hourly thresholds for part-time and full-time status. Once these standards are established, they must be honored. Based on generally accepted standards held by the Department of Labor and the Internal Revenue Service, consistently working hours per week is a common threshold for designation of employees as full-time. There have been a number of challenges to how marriages are defined at different state and federal levels, with cases focusing on the Defense of Marriage Act as well as whether and how to recognize same-sex marriage. The U.S. Supreme Court recently voted against DOMA, which changed the way terms such as marriage and spouse are defined and essentially treats same-sex spouses as same and opposite-sex married couples. This means that same-sex spouses may be entitled to certain benefit plans, and if same-sex couples get divorced, one partner may be entitled to a share of retirement benefits. In states where gay marriage is legal, companies have to consider whether to treat same-sex couples in the same manner as traditional married couples with regard to benefits. This issue is made even more complicated when organizations have operations in multiple states with varying laws. While insurance issuers cannot deny coverage to same-sex married couples, even in states where same-sex marriage is not formally or legally recognized, employers can elect to offer benefit plans that do not cover those individuals. Hiring and retaining older workers can be an important strategy for an organization seeking high-quality talent with a wealth of knowledge and experience. Modified work schedules, part-time benefits, and simplified seasonal travel can be attractive to older workers. Offering more choice leads to higher administrative costs for the organizations, but generally greater engagement and higher employee satisfaction with employee benefit options. Increases in employee expenditures for benefits are growing faster than increases for wages for employees. For example, during economic downturns, many organizations stop contributing to employee 401k plans, reduce education reimbursement, and cut training expenses. Companies are likely to wait until they are confident that they can afford the programs before benefits are reinstated. Another common means of benefit cost control is cost sharing, which refers to having employees pay for more of their benefit costs. The majority of firms use this strategy along with providing wellness programs, offering employee health education, and changing prescription drug programs. Organizations might also consider consolidating benefit packages into more streamlined offerings so that costs can be minimized. The Social Security Act of 1935 and its amendments established a system to provide old age, survivors, disability, and retirement benefits. Administered by the federal government through the Social Security Administration, this program provides benefits to individuals who were previously employed. Employees and employers share in the cost of Social Security through a tax on employees' wages or salaries. When the law was first enacted, employers and employees each contributed 1% of worker wages to the fund. By 1990, the rate had increased to 6.2% paid by each party, for a total of 12.4%, which is the current rate of payroll tax contributions. The amount of wages subject to tax is reviewed and increased periodically. Starting in 2015, the taxable wage base was increased from $117,000 to $118,500, with earnings over that amount not being subject to Social Security tax. Concerns persist about the long-term financial viability of the program. In response, the normal retirement age to receive maximum Social Security benefits has been steadily increased from 65 to 67, and it remains to be seen if further age increases will occur in the future. Medicare is a government-operated health insurance program for older Americans aged 65 and above, and for some citizens with disabilities. The Federal Insurance Contributions Act, or FICA, was passed to facilitate payroll contributions to support both programs. Medicare is funded by a tax on employers and employees. Each party pays 1.45% of employee earnings. Unlike taxes paid for Social Security, there are no earnings limits on Medicare contributions. Therefore, all wages earned by workers are taxed at 2.9%. An additional Medicare tax of 0.9% for individuals who earn higher incomes was instituted in 2013. Employers are expected to withhold this tax for compensation that exceeds $200,000 per year. The percentage that an annual employee pay increases from 2.35% from 1.45% on income that is earned above certain threshold levels, which are $250,000 for spouses filing jointly, $125,000 for spouses filing separately, and $200,000 for single wage earners. The future financial solvency of the program has been questioned, and legislative action in the coming years is likely to be needed to address the program's continuation. Workers' compensation are security benefits provided to workers who are injured on the job. Workers' compensation regulations require employers to provide cash benefits, medical care, and rehabilitation services to employees for injuries or illnesses that occur within the scope of their employment. In exchange, employees give up the right to pursue legal actions and awards. However, various circumstances may influence a company's obligation to pay workers' compensation. The concepts of no-fault insurance and exclusive remedy balance the rights of employers and employees under workers' compensation. No-fault insurance means that an injured worker receives benefits even if the accident was the employee's fault. Exclusive remedy means that workers' compensation benefits are the only benefits injured workers may receive from the employer to compensate for work-related injuries. In most instances, an injured worker cannot file a lawsuit for additional money. Workers' compensation programs are funded at the employer's expense. Workers cannot be required to make financial contributions for this coverage. Since each state operates independently, employers must be aware of various regulations if they operate in multiple states. Unemployment compensation is money that substitutes for wages or salary paid to recently unemployed workers under a program administered by a government or labor union. Each U.S. state operates its own unemployment compensation system, and benefit levels and job search provisions differ significantly from state to state. Each employer pays an unemployment tax that's based on an experience rate, which reflects the number of claims filed by workers who leave employment. Under normal circumstances, an employee who's out of work and actively looking for employment can receive up to 26 weeks of pay at a rate of 50 to 80% of normal pay. Most employees are eligible. However, workers fired for misconduct or those not actively seeking employment are generally ineligible. During times of widespread economic hardship, the government might increase the number of weeks during which eligible workers receive benefits. In recent years, unemployed workers could collect benefits for up to 99 weeks. The decision to extend benefits is often controversial, and legislators struggle to find a balance between providing income security to workers and reducing workers' motivation to seek employment. Unemployment compensation is meant to provide a source of income for jobless workers until they can find employment. A retirement plan is a program established and funded by the employer and/or employees to fund employees' retirement years. Organizations are not required to offer retirement plans to employees beyond contributions to Social Security. One such right, called vesting, gives employees a benefit that cannot be taken away. If employees resign or are terminated before they've been employed long enough to become vested, no pension rights accrue to them except for funds they've contributed. If employees work for the required number of years to be fully vested, they retain their pension rights and receive the amounts contributed by both the employer and themselves. Another feature of retirement plans is the concept of portability. In a portable plan, employees can move their retirement benefits from one employer to another. A retirement plan is a program established and funded by the employer and/or employees to fund employees' retirement years. Organizations are not required to offer retirement plans to employees beyond contributions to Social Security. A defined benefit plan is a retirement program in which employees are promised a pension amount based on age and years of service. A small percentage of companies in the private sector offer defined benefit plans to their employees, while public sector employers often still provide them. A defined contribution plan is a retirement program in which the employer and the employee make an annual payment to the employee's retirement account. The key to this plan is the contribution rate. Employee retirement benefits depend on fixed contributions and investment earnings. Profit-sharing plans, employee stock ownership plans known as ESOPs, and 401k plans are common defined contribution plans. Because of their portability and other features, these plans are sometimes preferred by younger, shorter-term employees. When individuals retire or begin working for other employers, they can keep the funds in their current account, withdraw the cash, and use or reinvest the money in some other way, or do both in varying degrees. The 401k plan gets its name from Section 401k of the Federal Tax Code. This plan allows for a percentage of an employee's pay to be withheld and invested in a tax-deferred account. 401k plans now dominate the field of employment-based retirement programs. These plans are attractive to employees because contributions are made on a tax-deferred basis, so the employee pays lower income taxes during working years. Of course, taxes must be paid when funds are withdrawn during retirement. There are other ways that employees can be encouraged to participate in 401k programs. One feature that can help is the use of automatic enrollment. Auto-enrollment is the process by which employee contributions to a 401k plan are started automatically when the employee is eligible to join the plan. Some companies set the initial contribution rate at around 3% of pay, but others are setting higher initial rates, from 4 to 6%. The employee has the ability to increase that rate or to stop contributions voluntarily. Some organizations use automatic increases of 1% a year to boost employee contribution levels unless employees voluntarily stop these increases. Financial education and consulting can be used to help employees understand how to manage their 401k and get the greatest value from the plan. People who use investment assistance earn better results on their investment funds than those who manage their own accounts. Overall, there are several approaches that organizations should use to improve employee participation rates, which include using automatic enrollment and increases to get the ball rolling, help workers roll over money from previous tax-deferred plans so that they dedicate more funds to retirement, keep an eye out for employees who need help managing their current accounts or help with retirement planning, custom tailor retirement communications to fit the needs of the audience, and adopt a holistic approach to retirement planning that considers all investments and potential streams of money. Some employers have changed traditional pension plans to hybrids based on the ideas from both the defined benefit and defined contribution plans. One such plan is the cash balance plan, a retirement program in which benefits are based on accumulated annual company contributions expressed as a percentage of pay plus interest credited each year. With these plans, retirement benefits accumulate at the same annual rate until the employee retires. Since cash balance plans spread funding across a worker's entire career, these plans work better for mobile, younger workers. Offering retirement plans are a staple of the total rewards mix in any organization, critical to attracting, retaining, and motivating talent. Employees often consider health plans to be one of the most important benefits that organizations offer. The most common plans cover medical, dental, prescription drug, and vision care expenses for employees and their dependents. Unfortunately, a recent study of government survey data found that 11.5 million fewer Americans were covered by organization-sponsored health insurance plans in 2011 compared to those who were covered in 2000. Findings also showed that fewer private organizations provided such plans over this time, and fewer employees enrolled in them. For several decades, the costs associated with healthcare coverage have increased considerably in the United States. This raises a number of concerns for both employers and employees because they have to pay for the coverage. Between 2000 and 2011, the average yearly premium for a single worker increased by approximately 100%, while the premiums for families rose approximately 125%. Landmark legislation enacted in 2010 changed healthcare in the United States. making insurance available for an additional 32 million people. Provisions of the Patient Protection and Affordable Care Act, known as the PPACA, were phased in over several years, culminating in universal coverage in 2014. The PPACA includes many important provisions intended to provide affordable health care for all citizens. To achieve this goal, enrollment in health coverage is now mandated for every citizen. Employers face a decision about continuing to offer their own health insurance plans or to drop their plans in favor of government-sponsored coverage. Employers with at least 50 full-time or full-time equivalent FTE employees who work at least 30 hours per week are required to offer minimum essential health care coverage to these workers and their dependent children until they're 26 years old. Healthcare coverage needs to be affordable, and employee costs cannot exceed government-mandated levels. Employers that fail to provide adequate healthcare coverage will pay an annual penalty of $2,000 per employee beyond the first 30 full-time workers. As a result, some employers are considering whether to cut staff or to reduce hours to avoid fines, while other companies have decided that it makes more sense just to pay the fines. Employers that offer coverage could pay an additional $3,000 penalty per employee for those who receive a premium tax credit to buy insurance because the plan would be considered too costly, using a benchmark of 9.5% of a worker's household income. Employers that provide a high-cost CADILLAC health benefit to employees may face a 40% tax starting in 2018. The threshold for this tax is $10,200 for an individual plan and $27,500 for a family plan. Employers offering healthcare benefits are taking a number of approaches to control and reduce their costs. The most frequently used strategies include the following: increasing deductibles and copayments, instituting high deductible plans, increasing employee contributions, limiting family coverage, switching to consumer-driven health plans, and increasing health preventative and wellness efforts. A deductible is money paid by an insured individual before the medical plan pays for medical expenses. Employers that raise the per-person deductible from $300 to $500 realize significant savings in healthcare expenses because employees use fewer healthcare services and prescription drugs. Copayments are a portion of medical expenses paid by an insured individual for medical treatment. For example, the health plan may require a fixed $20 copay for each physician visit. Alternatively, the copay may be used on a percentage basis, such as 20% of the medical treatment costs up to a set dollar amount. Companies can use increases to fixed copay amounts, increases to the percentage, or increases to the dollar amount that each employee shares for the costs. Employees are usually required to pay a portion of the monthly premium to maintain healthcare insurance. On average, single employees pay 18% of premiums, while employees with family coverage pay 28% of premiums. Over 50% of employers plan to increase the percentage that employees contribute to healthcare plan premiums. Several other types of programs attempt to reduce healthcare costs paid by employers. Managed care consists of approaches that monitor and reduce medical costs through restrictions and market system alternatives. Managed care plans emphasize primary and preventative care and use specific providers that offer lower prices, restrictions on certain kinds of treatment, and prices that are negotiated with hospitals and physicians. Preferred provider organizations, or PPOs, and health maintenance organizations, HMOs, are the most common forms of managed care. Spousal exclusion provisions limit access to a company's health plan when an employee's spouse works for another company that offers health insurance. Companies may charge a premium surcharge to enroll the spouse or require that the spouse enroll in his or her own employer's plan. Approximately 20% of employers have adopted these restrictions, and more organizations are planning to do so. Some employers are turning to health insurance plans that allow employees to choose their insurance. The most widely used is a consumer health plan, which is a health plan that provides employer financial contributions to employees to help cover their health-related expenses. Some companies have started to offer a variety of innovative healthcare programs to provide better services to employees. These policies have enabled organizations to encourage workers to focus more on healthcare matters and to participate in cooperative programs. Employees are often more educated about healthcare issues and available opportunities provided by their employers. The Consolidated Omnibus Budget Reconciliation Act, or COBRA, requires that most employers with 20 or more full-time and/or part-time employees offer extended healthcare coverage to certain groups of plan participants. The different groups are as follows: employees who voluntarily quit or are terminated, widowed or divorced spouses and dependent children of former or current employees, retirees and their spouses and dependent children whose healthcare coverage ends, any child who is born or adopted by a covered employee, and other individuals involved in the plan, such as independent contractors and agents or directors. A qualifying event is an event that causes a plan participant to lose group health benefits. Typically, reduction in work hours or loss of employment constitutes a qualifying event for employees. Divorce or death of an employee constitute a qualified event for covered family members. When a qualifying event occurs, a complex notification process begins. There are a number of deadlines that an organization and the employee must meet to comply with COBRA requirements. The individual no longer employed by the organization must pay all the premiums, but the employer may charge an individual up to 102% of premium costs. The extra 2% generally falls short of the true cost of providing this coverage. Compliance with COBRA regulations can be very complicated, and non-compliance with the law can lead to lawsuits and substantial penalties. Consequently, COBRA requirements often mean additional paperwork and related costs for many employers. COBRA administration is frequently outsourced to a third-party administrator that has the expertise and data processing capabilities. The Health Insurance Portability and Accountability Act, or HIPAA, of 1996 allows employees to switch their health insurance plans when they change employers and to enroll in health coverage with a new company regardless of pre-existing conditions. The statute also prohibits group insurance plans from dropping coverage for sick employees and requires them to make individual coverage available to people who leave group plans. One of the greatest impacts of HIPAA comes from its provisions regarding the privacy of employee medical records. These provisions require employees to provide privacy notices to employees. They also regulate the unauthorized disclosure of protected health information. In 2013, several revisions of HIPAA went into effect that call for companies to provide more training on new security and breach standards. HIPAA regulations provide important healthcare-related opportunities and protections for employees. Financial benefits offer employees a wide range of support to manage their money. Even when employers do not pay for any of the costs, employees still benefit because of lower rates available through group programs. The most common types of insurance benefits are the following: life insurance, disability insurance, long-term care insurance, and legal insurance. Financial benefits include a wide variety of items. A credit union sponsored by the employer provides savings, checking, lending, and other financial services for employees. Purchase discounts allow employees to buy goods or services from their employers at reduced costs, often at a company store. Discount programs and club memberships may also be offered to allow employees to purchase goods from other local vendors or club stores at lower rates. These programs are inexpensive for companies to implement and are viewed positively by employees. Employee thrift plans, saving plans, and stock purchase plans may also be available. To illustrate, in a stock purchase plan, employees may buy shares in the company at a discount, or the company pays the brokerage fees. This type of plan allows employees to benefit from future growth of the organization with the intention of increasing employee loyalty to the organization and interest in its success. Financial planning and counseling are valuable services for many executives, many of whom need information on investments and tax shelters because of their higher levels of compensation. The importance of these financial planning benefits will likely grow as a greater percentage of workers approach retirement age and need to plan for retirement. Another benefit that is popular with employees is education assistance and tuition aid, which pays some or all of the costs associated with formal education courses and degree programs. Many employers offer some form of education assistance to their employees. Some employers reimburse the employee for a percentage of tuition based on grades earned, while others may require only a passing grade of C or above. Companies may provide severance pay to individuals whose jobs are eliminated or who leave the organization by mutual agreement. The amount of severance pay is often determined by an employee's level within the organization and years of service with the company. Some employers provide continued health insurance or outplacement assistance as part of the severance package. Various types of financial services, insurance benefits, relocation assistance, education assistance, and other benefits enhance the appeal of an organization to employees. The Family and Medical Leave Act of 1993, known as the FMLA, is a United States labor law requiring covered employers to provide employees with job-protected and unpaid leave for qualified medical and family reasons. The FMLA was enacted in 1993 and has been amended several times. It covers all federal, state, and private employers with 50 or more employees who live within 75 miles of the workplace. Only employees who've worked at least 12 months and 1,250 hours in the previous year are eligible for leave under the FMLA. The law provides for unpaid leave. However, some organizations pay short-term disability benefits during FMLA leaves under certain conditions. The law requires employers to allow eligible employees to take a maximum of 12 weeks unpaid job-protected leave during any 12-month period. The FMLA covers the following situations: birth of a child and care for the newborn within 1 year of birth, adoption or foster care placement of a child, caring for a spouse, child, or parent with a serious health condition, and a serious health condition of the employee. A serious health condition is an illness or injury that requires inpatient care or continuing treatment by a healthcare provider for medical problems that exist beyond 3 days. An employer may require a medical certificate from a healthcare provider to support the reason for the employee's leave. Since the enactment of the FMLA, a significant percentage of employees have taken family and medical leave. Employers give employees paid time off for a variety of circumstances. Paid lunch breaks and rest periods, holidays, and vacations are common. But time off is given for many other purposes as well, including various leaves of absences. Employees place a high value on paid time off, and some prefer time off rather than extra pay. Paid vacations are a common benefit. Employers often use graduated vacation timescales based on employees' lengths of service. However, some organizations have a use it or lose it policy whereby employees forfeit any vacation time not used during that year. Other organizations have policies to buy back unused vacation time, or they allow employees to donate unused vacation days to a pool that can be used by other workers. Most employers provide pay for a variety of holidays. Employers in the United States commonly offer fewer paid holidays than those of many other countries. The number of paid holidays can vary depending on state, provincial laws, and union contracts. Employers grant leaves of absences taken as time off without pay for a variety of reasons. All of the leaves discussed here add to employers' costs, even though they're unpaid, because the missing employee's work must be covered, either by other employees doing extra work or by temporary employees working under contract. Leaves are given for a variety of reasons. Some, such as military leave, election leave, and jury duty leave, are required by various state and federal laws. Employers can pay the difference between the employee's regular pay and the military, election, or jury pay. Federal law prohibits discriminating against military reservists by requiring them to take vacation time when deployed or in training. Funeral leave, or bereavement leave, is another common type of leave offered. An absence of up to 3 days for the death of an immediate family member is often granted. Some policies also allow unpaid time off for the death of more distant relatives. Many employers allow employees to miss a limited number of days because of illness without losing pay. The majority of U.S. workers receive paid sick leave. Some employers allow employees to accumulate unused sick leave, which may be used in case of a catastrophic illness. Others pay their employees for unused sick time. If an organization does not pay workers for sick time, it might be encouraging them to come to work when they're ill, causing lower productivity or spreading illness and disease. A growing number of employers have made use of paid time off or PTO plans. These plans combine all sick leave, vacation time, and holidays into a total number of hours or days that employees can take off with pay. Many employers have found these PTO plans to be more effective than other means of reducing absenteeism, scheduling time off, increasing employee understanding of leave policies, and assisting with recruiting and retention.